May I at this time reserve my right for rebuttal time following counsel's argument?
Yes.
Thank you. We're here today on two issues of appeal. Number one, whether the Peoria County Circuit Court erred in its application of 750 ILCS 5-503B1. And number two, whether the Peoria County Circuit Court abused its discretion in failing to appropriately consider Stephen Martin's premarital and marital contributions. As I am aware that your honors have reviewed all of the briefing and background facts in this case, I would like to just walk through a couple that I believe will be relevant for today's argument. The Peoria County Circuit Court entered a judgment of dissolution on April 24th of 2024. This matter was then set over for trial on October 24th of 2025, and the remaining issues were detailed in a written ruling by the court on December 8th, 2025. While there were various agreements and stipulations made by the parties, there were a few issues that the court's order walked through and addressed, and I will go through those two issues briefly. Number one was the home owned by the parties during the marriage. I will refer to this home as the Rosemead home or the Rosemead residence throughout my argument. Um, Obviously, this home was purchased by Marlene in 1991 and was shared jointly by the parties during the marriage. Number two was the cash, the gifts, and the inheritance checks that were received throughout the marriage. These two issues were detailed within the order. Substantive evidence was not able to identify the whereabouts of the funds, some of the silver, and where those funds went as that time went on. And the court's ruling detailed that Marlene was to be awarded the residence and ordered Marlene to pay $8,771, which was representative of the increase in value from the home from 2014 until 2024. Again, the court stated that they could not find sufficient evidence that either party misappropriated property or where the missing coins were located, and that the court could only award funds that were confirmed there and available to the parties. Lastly, the court awarded Marlene to pay Stephen $2,000 for the cash that was there at that time and $10,000 for half the value of the coins purchased after the marriage. In this matter, and the 2 points that I will walk through here today, the standard of review is whether the trial court's findings of facts are against the manifest weight of the evidence or whether the property distribution or awards of the maintenance, child support, and the attorney's fees amounted to an abuse of discretion. This was set forth in the fourth district case in re Marriage of Charles in 1996. And again, in People v. Morgan, as cited within our brief, a trial court abuses its discretion if it fails to apply the proper criteria when it weighs the facts, and a reviewing court must consider both the legal adequacy of the way the trial court reached its results, as well as whether the results is within the bounds of reason. Which leads me to my first point of my argument. The Peoria County Circuit Court erred in its application of 750 ILCS 5-503B1. As you are all aware, this act provides that property acquired during the marriage and held in joint tenancy or in tenancy in common is presumed to be marital property regardless of the origin. As I stated within the facts, this home was purchased by Marlene prior to the marriage. It was then transferred by deed jointly to both parties as they were married. So therefore, this would therefore trigger the statutory presumption that this was marital property and clear and convincing
Let's
evidence.
assume for the moment, that it's marital, or let's assume that it's non-marital. What difference does it make in this case? The
Yes,
court,
Your Honor. Yes, Your Honor. Thank you for that question. Within 750 ILCS 5-503, it is stated that the court shall make specific factual findings as to the classification of the asset as marital or non-marital. There was never a actual classification within the court's order or within the transcript from that trial. We believe from our position that to make a designation is one, very important, but to make a designation as marital property would then allow the court to evaluate the time that was put into the home, the work that was put into the home, and the funds that were then put into the home as a couple jointly benefiting from the home at that time.
Thank you. But what did the court do that was wrong?
Outside of outside of that finding or having the presumption of the property being marital or non-marital property, there is not an evaluation from our perspective of a true valuation of what our client put into the home. One, the
But
funds.
the trial court heard your client and heard the evidence.
Yes, absolutely, Your Honor. And again, uh, we believe that without having the classification of a true marital or non-marital property was a wrongdoing by the court due to the fact that the statute would then apply to the evaluation given between non-marital and marital property.
Well, let's just view it as marital property.
Okay.
Was the court entitled to divide it the way that it did?
The court, based upon the language of the statutes, only awarded Stephen a portion of the interest that he had in increase in value from the time 2024, or excuse me, 2014 until 2024 when he had gone out and received the last appraisal. Um, this this amount of money would not result in an actual distribution that is reasonable or would be equitable under Section 503. We have to evaluate the financial resources, labor to the marital estate with the parties jointly benefiting from both the marital income and the substantial inter vivos gifts that were given during this time. While there was not a credibility determination at at the time of trial or within the order, we believe that the evidentiary record indicates a greater reliability in Stephen's testimony. All of this testimony together results in the fact that he had installed a fence, a shed, flooring, electrical outlets, and I could continue to go on and on based upon that testimony given. These were not just small improvements, these were substantial improvements to the home that both parties in the marriage were starting to benefit from. And financial expenditures on top of that would also be considered with the fact that this would be marital property if we were to consider that. $45,000 from the sale of his premarital home and $35,000 that was taken from a retirement account and liquidated was deposited into marital use and expended for household expenses as well as improvements that were made. We believe that due to the fact that this was not given a designation, again, assuming at this point in time that that property is considered a marital asset, these figures and this work would then be contributed to the court's decision, viewed in.
Let me ask another question. Did the parties, well, primarily your client, did he distinguish between the money that was used for improvements and the money that was used to cover expenses of the household, which I assume means utilities and groceries and things of that sort? Was that separated out?
Yes, Your Honor. In terms of an exact amount, no. Those values were considered, again, the $45,000 and the $35,000 were just considered to be deposited into the marital estate and used for those functions. An exact designation was not given.
Well, if some of it was given toward or used toward the ordinary expenses of daily living, that's sort of like he was contributing to the household in a way that he would have been if he's there paying rent. I mean, I don't understand how that whole amount means anything unless there is some description. I understand the part about the shed, and, I did this and I did this, but contributing toward the ordinary expenses of a household doesn't automatically require the trial court to give him a greater share of the house.
Yes, Your Honor. And in terms of those funds, I would agree. As we've moved forward in as the parties testified at trial, the inheritance money became somewhat of an issue. The checks that were written to both parties during that time, that value equaled around $100,000 that was given it at that time to be used again for home improvements as well as the daily living within the home. Many of those checks, which throughout the trial were signed and given to Stephen Martin as well as Marlene Martin, making those funds, in addition to the $45,000 and $35,000 that he had liquidated, into the marital asset that was used to improve the home and live in the home. So while I very much understand your point of his money that went towards the home and if for lack of a better word, paying rent for those daily expenses and home living, there was another $100,000 that both parties jointly used to improve the home and live in the home as well. That would then be brought into consideration using the statute if this were to be considered marital property. And an award to my client, Stephen Martin, of less than 5% of the home's value does not reflect a reasonable balancing of what each party presented in terms of testimony or the statutory factors that are set forth in 503. And that's why we believe, Your Honor, that reversal is warranted under the discretionary analysis and remand is required for the distribution consistent with the full evidentiary record and the equitable principles embodied in Section 503. Mainly with that point, having a designation of one, either non-marital or the home being a marital asset. Within the response filed by the appellee, the home there's actually zero contention as to how the home should be designated. Therefore, again, we believe that this should be remanded to walk through those factors in Section 503, walk through the financial testimony of each party, and make a true designation. This home as marital property, this should be the award. Our position is that 5% of that value does not reflect a reasonable balancing whatsoever.
Let me ask you another question. You said these checks. Am I remembering correctly that a lot of the checks came from her family, though
Yes, Your Honor.
they were addressed, the checks said, you know, to both of them. Well, how much does that total? The amount coming from her family and the amount that you assert that your client contributed.
Yes,
What
Your Honor, and I would be happy to pull up the exhibits with the checks from what I can recall, as well as
we use the figure of $100,000,
yes,
but that would not count the 70, $80,000 that you contend that your client contributed.
yes, Your Honor. We would contend that the $80,000 was contributed from our client himself, and $100,000 that was given in inheritance based upon the signature on the check would be jointly given to both parties with the intent for them
Okay.
to use it for the home improvement.
There was $180,000 in home improvements or money that could have been used for home improvements. How much did it increase the equity in the home or the value of the home rather?
Yes, Your Honor. That the home the home was determined to be worth 195,000. Half of that was given to my client, so $8,771. So times that by two, that was the increase between the 2014 value that was given to the home and the 2024 value that was determined at 195,000.
So separating out some of that money just being used for living expenses, that was still well over $100,000 in improvements, you would suggest, but it only improved the value of the home by $16,000 or 18,000.
Yes, Your Honor. And, subjective to the values that were given within the appraisal, I think it should be taken into consideration who completed the work, what kind of work was completed. In general, many times there's work that's done in a house that's routine maintenance or maintenance that doesn't necessarily increase the value of the home itself, but was done by my client. There's many examples of the work throughout that time that was done you know, improving the home, the livability of both parties and their experience within the home that may not have been reflected in that $195,000 2024 valuation.
Okay, thank you.
Your Honor, at this time, I would just like to close that the circuit court property distribution is not supported by the record or Section 503 of the Illinois Marriage and the Dissolution of Marriage Act, and the court should therefore reverse and remand for reconsideration of property classification, cash and silver allocations, and the parties' respective contributions. Thank you.
Thank you, counsel. We'll hear from you on rebuttal.
Thank you.
Ms. Ramos?
Yes, Your Honor. Since I've already introduced myself and my client, I would start out by saying there are 2 points that I would like to address in my time before the court. The first being that the property at 4621 North Rosemead Drive was marital property. And second, that the court did not abuse its discretion in its distribution of the marital property. In fact, the court considered the statutory factors in front of it in deciding it or making its ruling. First off, the Rosemead House was part of the judge's order, and every part of that order considered or addressed marital property that the parties had. And that's clear by the fact that the court set out the statutory factors that go into that are considered when dividing up marital property. And so the Rosemead House included in that distribution, and the factors that the court considered in making its distribution make it clear that it was marital property. Second, both names were on the property. And as this court knows, under Illinois law, there's a presumption that when non-marital property is transferred into a form of co-ownership, the presumption is that it is marital property. That's what we have in this instance. Third, the court is bound to distribute or divide the property after assigning the non-marital property. Then that's what the court did in this instance. It divided the Rosemead House between the 2 parties.
Let me be clear, or let me ask a question.
Sure.
The trial court never specifically said it was marital property, but your contention is the way the order is drafted, the way the decision is made, it's clear to you and your client that the court was treating it as marital property. Is that correct?
That is correct, Your Honor.
Thank you.
And I believe that there's case law that says where a court could find that the property was marital property and treated the property as marital property, then there was no error in the court's ruling. My final argument in support of the fact that the Rosemead House was marital property is the fact that no one argued otherwise. Neither of the parties argued, certainly not by clear and convincing evidence, that the Rosemead House was anything other than marital property.
What do you think the trial court believed or concluded or found regarding these rather large sums of money that apparently flowed through the marriage? What were they spent on?
Your Honor, there were large sums of cash between the parties. When the parties married, my client had between $140,000 and $150,000 of cash in the party's safe. There were checks given to the parties during the course of the marriage. I can't say what the money was spent on. We didn't try to argue that there was any kind of fraudulent behavior by any party. Just all Marlene testified to is by the time the parties separated, there was only $7,000 worth of cash left. And the court has already made a note of the house increase in value of only $17,000 and change during the 10 years time. I can't say that all that money went to the improvement of the house. In fact, the court pointed out that there was conflicting testimony regarding the improvements made to the house. So no one knows where the money went, or no one testified to where all that money went, Your Honor.
I'm not suggesting any inference should be drawn from this, but it appears as if, regarding both parties' memories, there is silver and cash that they really can't account for. They really can't account for where it went.
That is correct. My client did account for in receipts the amount of silver she purchased before the marriage, and also with evidence of receipt for the coins that were purchased after the marriage. And that was only $20,000 worth of
Right.
coins.
So we don't really know what happened to the silver that she brought to the marriage.
That is correct. She testified that she thought approximately $45,000 worth of her collectible coins, which she considered her pension, was missing by the end of the marriage.
Thank you.
Thank you. Second, as to the abuse of discretion, Stephen wishes the court to find that the court abused its discretion in its distribution of marital property. But case law is very specific that the court has broad discretion in its distribution of marital property. And furthermore, that discretion is not to be overturned unless there is a finding of abuse of that discretion. And that abuse can only be determined if a reasonable person would have found differently than the court did in its ruling. And furthermore, the appellate court is to give deference to the trial court's ruling in that it was in a position to better observe the demeanor and testimony of the witnesses before it, or the parties before it. The court had only three assets to consider, and that was only three assets that the parties agreed upon, and that was the $4,000 worth of cash remaining in the safe, $20,000 worth of collectible coins, and the Rosemead house. And the court divided the cash, the $4,000 in half, the collectible coins, the $20,000 that both parties purchased, in half, and then, as far as the Rosemead house, divided the equitable interest in the increase of value in the Rosemead house in half. So the court was very thorough in its division of the property. Some of the statutory considerations that the court had were the age and economic circumstances and employment of the party. As pointed out in the brief, Marlene is 71 years old. Stephen is 69 years old. They're both retired. There's no testimony or evidence that either had planned on further employment. But the parties had agreed on maintenance before the testimony was even heard by the trial court, and that was based on the great economic disparity in the income of the parties. The parties had agreed that Stephen would pay Marlene $253 a month for 58 months, I think. Oh, might have been, I'm sorry. But that was based on exactly Stephen having an income twice as large as Marlene at the time of the trial in 2025. In addition, there was other evidence that Marlene testified that she couldn't afford to pay rent if she was forced to sell the Rosemead house. Additionally, there was $45,000 worth of coins missing, and that she was the one who had only one vehicle at the time of the trial, where Stephen had three vehicles and an inheritance account at the time of the trial before the trial court. Another consideration would be the parties' contributions to the Rosemead house, or to all the marital property. And Marlene contributed the house, the Rosemead house, which was 100% paid off at the time of the parties' marriage. And Stephen's name wasn't added to it until 2 years later. And this was a house that she had lived in since 1991, paid for, cared for, remodeled, and paid the taxes, paid the insurance. And Stephen was not added till much, much later. Also, Marlene was the one who paid for Stephen's Nissan King Cab and her own Nissan Murano. Um, as this court knows, equitable does not mean equal. After all, it wouldn't be equitable for someone who had owned, cared for, and completely paid for a house from 1991 till till their marriage in 2014, to have to be forced to sell the house to pay off her ex-spouse for a share of the house that would not be equitable, considering she had put all that money in. And as this court pointed out, there was only a 17,000 and change amount or increase in value of the house from the time the parties married to the time the parties divorced, or the 2024 appraisal of the house. So based on that presumption, or based on that, the court made the only decision it could in dividing the increase in value of the Rosemead house by half and dividing it just like she did with the coins and the cash in the safe, divided it by half. But the equitable increase in the value of the house, or the appreciation of the house, versus dividing the entire house otherwise. Which leads me to my final point. We had asked the court to take judicial notice in our appellate argument that after the court had its hearing or heard this trial, a petition to revive a judgment was filed in a previous matter, a previous divorce case that Marlene had, specifically 2003 D 257, or Peoria County case, 2003 D 257, where the petition asks the trial court to order that that judgment be maintained for the heirs of her deceased ex-husband. And that petition was only filed after the trial in this matter, and the ruling by the trial court on the petition to revive the judgment wasn't entered until January of 2026. So it wasn't a matter we could bring to the trial court's discretion. And any person would want to bring that to the trial court's discretion if they knew it would mean that their ex-spouse would not be entitled to half the house, or would not be half the house would not be available to the parties in the decision of the trial court. Stephen goes on to characterize Marlene as having unclean hands for not revealing this to the trial court. Unclean hands is a defense only available in equitable matters, which is not what this court has in front of it. Instead, Marlene only brings the petition to revive the judgment and the order regarding the same to the court's attention, to the appellate court's attention, to say, ask the court to take judicial notice of that, that half the house was already spoken for by the heirs of her deceased ex-husband. And therefore, the court's decision, or the court's ruling, our trial court's ruling in this matter, was even more equitable to Stephen than was known at the time the court entered its decision. And for the above reasons, the appellee asked this appellate court to affirm the trial court's decision, or the trial court's ruling, as the court's ruling was not an abuse of discretion, and no reasonable person would have adopted a ruling other than that was made by the trial court, and that the court considered all the evidence before it and the statutory factors it had applied to make its ruling, especially given the vast economic disparity between the parties and the great contributions made by Marlene to the Rosemead house before the parties' marriage, and the few assets, just the three assets the trial court had at its disposal to reach its economic distribution of the same. I would be happy to answer any questions you have with my remaining time.
I see no questions. Thank you for your argument, Ms. Ramos. And Mr. Woods, rebuttal.
Yes, thank you, Your Honor. First of all, I would like to address the point regarding that there was a true designation between non-marital and marital property in terms of the home. As stated in my earlier argument, the court shall make a specific factual finding as to its classification. In our opinion, this was not done. Within the court's order, there was language included about the idea of duress when the house was transferred into both names of the parties, and there was never a stipulation that the home itself was considered marital property. And there is not at any point within the record from trial either that would support this point. Rather, the court made. I'm sorry.
Equally apparent, though, is that there wasn't a finding that it was non-marital as well, correct?
Yes, Your
The
Honor.
court just didn't make a finding at all.
Yes, Your Honor.
Okay, thank you.
As we have walked through this case and reviewed the findings that were set forth, the court's order did not state whether the property was marital or non-marital. Rather, it made an implication that the property was non-marital by the findings through what was presented to the court. There was no explicit finding of either party's testimony that had the ability to show a true designation of marital or non-marital, but the treatment given to how the property was dispersed, funds-wise, and what have you, would track closer with a non-marital designation rather than a marital designation. Which leads me to point number two, that the trial court did abuse the trial court did abuse its discretion in its division of the party's property. While there were findings that were not able to be fully drawn out in terms of the silver and the money that was handled by each party in this case, despite the admission that there wasn't true and actual evidence, the court proceeded to assign value to distribute equity without explaining how it resolved and how it worked through the conflicting evidence, whether it credited either party's testimony, and how it weighed the statutory factors. Without such findings, the complete distribution of the assets lacks the reasoned analysis required. And the trial court's failure to address these inconsistencies that we had within the evidence, as was presented to the court, the rent that would be required to pay if the home was sold, the expenses that would then come into question. Marlene testified during the trial that she paid all the bills and that Stephen made no meaningful financial contributions, while at the same time asserting a need for maintenance and accepting of a maintenance award. These positions cannot be reconciled. So, therefore, the trial court's failure to address these inconsistencies, coupled with the failure to make any findings explaining how the evidence was evaluated, results in a distribution that was not grounded in the record and constitutes an abuse of discretion. As explained by counsel, the idea of the former case to be taken as judicial notice, we would agree. While this issue did become of a nature that needed to be addressed after the trial, the evidence that was presented from all the actual proceedings that took place indicate that Marlene had a signature that was not only signed by her but also notarized in terms of the proceedings that took place on April 17th of 2003. Similar to her trial testimony that she bore the financial responsibilities for the household, while simultaneously asserting a need for maintenance, invoking income disparity to justify the property distribution, there's an inconsistency with the idea of this case being involved now too. For all of these reasons, Stephen respectfully requests this court to reject Marlene's assertion that there was no dispute as to the classification of the Rosemead property, find that the trial court failed to make the findings necessary to support its actual distribution of the parties' assets, and decline to affirm a judgment resting on inconsistencies and unsupported positions. Stephen further requests that this court reverse the property distribution entered in this case and remand the matter to the circuit court for further proceedings consistent with this court's ruling, including a clear determination of the property's classification and a redistribution of the marital estate based on complete findings and an accurate record. Thank you all.
Thank you, counsel, both of you, for your arguments. We'll take this matter under advisement, and await the readiness of our next case. Thank you.
Thank you.